Author Michael Wolff has claimed in a lawsuit that First Lady Melania Trump threatened to sue him for over $1 billion in damages if he didn't retract Jeffrey Epstein-related statements he made about her. Wolff said in the lawsuit that Melania Trump's threat to sue came over statements he made to the Daily Beast and in 3 videos published on social media, although he added some statements were incomplete phrases and were taken out of context. The lawsuit came on Tuesday, the deadline set by Melania Trump's lawyer for Wolff to retract statements, issue an apology, and pay damages to his client. Through his lawsuit, Wolff announced his intention to use the legal action to put the president and his wife under oath to answer questions about Epstein. Wolff conducted interviews with Epstein before his death. The lawsuit noted that Wolff never said Melania Trump was involved in any of Epstein's crimes. Among the statements the lawsuit said were true were those saying Melania Trump was very involved in Epstein's social circle where she met her future husband, and that it was fair to question how Melania Trump fits into the Epstein story. Wolff has published a dozen books, including 4 bestsellers.
Hey guys, welcome back. Dr. John is in session. So this has just happened, guys. An authentic FBI interview summary from the newly released Epstein investigation files has landed directly in the middle of Melania's legal war against Michael Wolff, an official federal document she cannot discredit with a cease and desist letter. The carefully curated narrative she spent years building just took a direct hit from the one source that's almost impossible to wave away. The FBI interview summary states, in the cold bureaucratic prose of a special agent typing up witness testimony, that Melania served as a crucial component of the puzzle. The document details how Melania sheds enormous light on the entire Epstein and Trump dynamic.
I got a letter from him saying, you gotta not talk about Melania and Trump, or we're going to sue you for $1 billion. Before they could sue me for $1 billion, and the likelihood is that they probably had no intention of suing me, that this was just an effort to intimidate me. But before they could do that, we went into court and sued them in New York State under laws expressly against using the libel statutes for the express purpose to intimidate legitimate speech. So that happened. We filed that suit on October 22nd. Now, in that time, and that's almost 10 weeks ago, one of the things that we have been trying to do is to serve the First Lady.
These are not the words of a political operative or a tabloid journalist. These are the recorded observations of a federal investigator documenting the sworn account of a cooperating witness, someone who worked inside Epstein's inner sanctum and spoke to agents under a proffer agreement that demanded absolute truthfulness under penalty of criminal prosecution. The witness described how Jeffrey Epstein personally introduced Melania to Donald Trump, directly connecting the future First Lady to the man she now claims barely registered as a presence in her life. The narrative Melania has aggressively defended through legal intimidation, the version of events she presented to the American people from behind a White House podium, has just collided head-on with evidence that carries the weight of the federal government.
The lies linking me with the disgraceful Jeffrey Epstein need to end today. The individuals lying about me are devoid of ethical standards, humility, and respect. I do not object to their ignorance, but rather I reject their mean-spirited attempts to defame my reputation. I never been friends with Epstein. Donald and I were invited to the same parties as Epstein from time to time, since overlapping in social circles is common in New York City and Palm Beach. To be clear, I never had a relationship with Epstein or his accomplice, Maxwell.
To understand why this moment is so explosive, you need to grasp the full scope of this legal confrontation. Michael Wolff is not some reckless internet provocateur who stumbled into a story too dangerous for his experience. He is the investigative journalist who cracked open the Trump White House with his book Fire and Fury, a work that sold millions of copies and exposed the administration's internal chaos with surgical precision. When Wolff turned his attention toward Melania Trump and her connections to the Epstein network, he applied the same methodology that built his reputation. He cultivated sources, secured documentation, asked uncomfortable questions, and reported exactly what the evidence suggested, regardless of how many legal threats arrived in his mailbox. Wolff conducted extensive interviews with Epstein himself before the financier's death, and he has been pursuing this story with the tenacity of a reporter who knows he is sitting on something significant. He is not guessing, he is not speculating, he is methodically assembling a case built on documentation and first-hand accounts. The moment Wolff's reporting began connecting dots that Melania desperately wanted to remain disconnected, her legal machinery responded with characteristic ferocity. This is the Melania playbook refined over years of practice. When a journalist or media outlet gets too close to questions about her relationship with Epstein, they receive a letter. Not a polite request for a correction, not an invitation to discuss the facts. They receive a legal communication threatening defamation damages so astronomical they would create serious financial strain for any individual or organization. The Daily Mail received this treatment and ultimately capitulated, issuing a public apology and retraction to make the legal pressure stop. The Daily Beast faced the same approach. Various commentators and book publishers discovered they were targets of the same coordinated legal strategy, all designed to communicate one unmistakable message. Mention Melania and Epstein in the same context and expect to face devastating financial consequences. This is not the behavior of someone who is merely annoyed by inaccurate reporting. This is the behavioral signature of someone who is deeply concerned about what a comprehensive investigation might uncover. When Wolff published his findings and Melania's legal team dispatched their standard threatening correspondence, they made a catastrophic miscalculation. They assumed he would calculate the cost-benefit ratio of fighting back and quietly retreat like other targets had done. They assumed wrong. Wolff did not just ignore the letter. He transformed it into the centerpiece of a legal counteroffensive so audacious it almost certainly caught Melania's attorneys flat-footed. He marched into New York Supreme Court and filed a declaratory judgment action anchored in the state's anti-SLAPP legislation, statutes specifically engineered to protect journalists and whistleblowers from exactly the kind of weaponized litigation Melania's team had been deploying. By seizing the initiative, by filing first in a jurisdiction with the nation's most robust protections against strategic lawsuits against public participation, Wolff executed a legal maneuver of considerable strategic brilliance. He converted Melania's billion-dollar threat into a judicial proceeding. He transformed her intimidation campaign into evidence, and he informed the First Lady of the United States in language as formal as a legal notice that he would not be silenced, he would not be financially coerced into submission, and he would not stop asking the questions she was so desperate to suppress. Wolff stated the matter plainly. He received a letter demanding he cease discussing Melania and Trump. Before they could sue him for $1 billion, he went into court and sued them first. This fundamentally altered the power dynamic of the entire dispute. What happened next in this legal chess match reveals more about Melania's defensive strategy than any press release ever could. Once Wolff's lawsuit landed, her legal team faced a binary choice. They could engage with the substance, argue that his reporting was factually erroneous, and fight him in open court using evidence. Or they could pursue a familiar legal tactic employed when the facts are problematic. They could obstruct, delay, and attempt to move the battlefield to friendlier terrain. They chose the obstruction path with almost mechanical predictability. Melania's lawyers approached the federal judiciary and requested that the case be extracted from the New York State Court, where Wolff had strategically positioned it. This maneuver successfully transferred the proceedings to the United States District Court for the Southern District of New York, landing on the docket of a federal judge. This was not a neutral administrative adjustment. This was a calculated move specifically designed to weaken Wolff's legal protections. New York State anti-SLAPP laws provide robust shields for journalists. Federal anti-SLAPP provisions offer considerably less coverage. By shifting the venue, Melania's legal team deliberately eroded the very legal protections Wolff had raised, and they executed this maneuver with full awareness of what they were doing. But the procedural gamesmanship did not conclude there. Melania's legal team then advanced an argument so questionable it would strain credulity if the stakes were not so significant. They claimed that Melania had never been properly served with the lawsuit papers. Let the implications of that claim fully settle. The First Lady of the United States, one of the most photographed human beings on the planet, a woman who moves through the world perpetually surrounded by a Secret Service protective detail, argued to a federal judge that nobody could locate her to hand her legal documents. Wolff addressed this assertion with the bone-dry sarcasm it deserved. He noted that encountering her on a public sidewalk for casual service of process was logistically impossible, and that strolling into the White House to serve papers was equally fantastical. The woman who has dispatched legal threats across multiple continents to silence critics was suddenly, conveniently, a person who could not be found. This service dispute became yet another layer of delay, another procedural hurdle carefully designed to exhaust Wolff's resources and patience before he could ever ask a single question under oath. Then came the Florida maneuver, perhaps the most revealing strategic move of all. Not satisfied with merely escaping the New York State anti-SLAPP regime, Melania's legal team pushed aggressively to transfer the entire case to the Sunshine State, where she and the president maintained their official residence. On its surface, this appeared to be a routine dispute about proper venue, but context transforms the analysis entirely. Florida, in this particular legal landscape, carries an extraordinarily specific implication. It introduces the possibility of the case landing before a judge appointed by Donald Trump. Not just any Trump appointee, but the specific possibility of drawing Judge Aileen Cannon, the same jurist whose handling of the classified documents prosecution against Trump generated significant examination from legal observers across the ideological spectrum before she was ultimately removed from that matter. The notion that Melania's legal team was engineering a pathway toward a particular courtroom is not a conspiracy theory. It is a logical interpretation of a deliberate legal strategy. Wolff himself identified this publicly, pointing directly at the Trump-appointed judge angle because he understood precisely what the Florida maneuver represented. It was not about geographic convenience or judicial efficiency. It was about seeking the most favorable adjudicator available. Wolff has contested every dimension of this procedural battlefield. He filed a detailed opposition to the motion to dismiss while simultaneously moving to remand the entire case back to New York State Court, arguing that the removal to federal jurisdiction was legally defective from the moment it was executed. His position has remained unwavering throughout. This case belongs in New York, where the law is specifically constructed to protect journalists from precisely the kind of legal pressure Melania has systematically deployed. Both motions are now fully briefed and resting on the judge's desk, awaiting a ruling that could fundamentally reshape the entire architecture of the dispute. The case has survived every attempt to kill it. It has not been dismissed. It has not been transferred to Florida. It is alive. It is advancing through the judicial process, and it presents genuine legal risk to the defendant. Then came the moment that electrified everything. Melania Trump walked into the grand foyer of the White House, positioned herself behind a lectern, and delivered a prepared statement to the nation about Jeffrey Epstein. She declared with rehearsed conviction that she was not his victim. She insisted categorically that Epstein did not introduce her to Donald Trump. She characterized her proximity to Epstein as nothing more than the incidental overlap of social calendars, the kind of glancing contact anyone navigating elite circles in that era might have experienced. She described her critics as engaged in vicious defamation campaigns. She labeled their reporting as lies, pure and simple. She claimed she was never friends with Epstein, that she and Donald merely attended the same parties from time to time since overlapping in social circles is common in places like New York City and Palm Beach. She stated with emphasis that she never had a relationship with Epstein or his accomplice Ghislaine Maxwell. She dismissed her email correspondence with Maxwell as nothing more than casual pleasantries, a polite reply that did not amount to anything beyond a trivial note. And then, without acknowledging a single question, without submitting to a single moment of cross-examination, she turned and walked away from the podium. If you possess even a rudimentary understanding of how the legal system operates, alarm bells should be sounding at maximum volume. Why would the First Lady of the United States stage a nationally televised press conference about an active federal lawsuit in which she is a named defendant? There exists a foundational legal doctrine called sub judice, which establishes that parties to ongoing litigation must not make public declarations specifically designed to prejudice the proceedings or influence the tribunal. The principle is well established in American jurisprudence. You do not try your case in public when it is actively being litigated before a judge. The courtroom is the appropriate arena for presenting evidence and making arguments, not the White House briefing room with its presidential backdrop and its implicit authority. Melania disregarded this doctrine entirely and held the press conference anyway, transforming what should have been a legal proceeding into a public spectacle. Wolff's response was immediate, pointed, and laden with legal significance. He stated that her public remarks directly contradicted much of the evidence. Read that sentence again and absorb its full weight. This is not a journalist waving his hands and calling her names. This is a plaintiff in an active federal lawsuit, a man who has reviewed the materials and knows precisely what his case file contains, informing the world on the record that the defendant just stood behind a presidential podium and made statements that his evidence unmistakably contradicts. He specified that her statement contradicts the known timeline and, most significantly, contradicts what Jeffrey Epstein himself directly said about her. This is Wolff signaling with the confidence of someone who believes he holds substantial evidence that he possesses material, whether recordings, documents, witness statements, or other forms of proof that directly challenges her public declarations. He is not speculating. He is not theorizing. He is informing the public that the defendant made statements at a White House press conference while an actual court case against her remains pending, and that those statements do not align with the evidence he intends to present. Wolff offered several penetrating theories about why she held the press conference at all, and each theory adds a layer of complexity to a situation already unprecedented in American history. His first and most legally significant theory is that the press conference was an attempt to influence the judge. He noted pointedly and publicly that the judge currently presiding over the case is a Trump appointee. The implication lands with considerable force. Wolff is suggesting that the First Lady of the United States may have used the White House podium to communicate a message to a federal judge who has a pending decision to make in her case. If that theory holds water, the press conference was not a public relations strategy. It was an attempt at influencing judicial proceedings wrapped in designer clothing and delivered with presidential optics. Wolff connected this directly to the central thesis of his lawsuit, stating that intimidation is precisely what his case against her concerns. In this interpretation, the press conference is not a defense against his claims. It functions as additional evidence supporting them. His second theory aligns with what crisis communication experts recognize as getting ahead of the story. When you know a damaging piece of information is about to become public, you move first. You seize the narrative, you control the timing, and you attempt to frame the information before it arrives in its raw form. Wolff suggested that the press conference was precisely this maneuver, a preemptive strike indicating that Melania's team knew something significant was coming their way and were racing to shape public perception before it landed. If this theory proves accurate, the White House address was not a confident assertion of innocence. It was an urgent defensive action designed to get ahead of revelations they knew were imminent. And then the FBI document surfaced, and suddenly Wolff's second theory looked considerably less like speculation and considerably more like accurate predictive analysis, because the document pulled from those millions of Epstein files dated from a federal interview conducted with a woman who served as Epstein's personal assistant, a woman who gave her testimony under a proffer agreement, meaning she was legally obligated to speak truthfully under penalty of criminal prosecution, states explicitly in the recorded words of an FBI special agent that Epstein introduced Melania Trump to Donald Trump, not as hearsay, not as tabloid speculation, not as the musings of a disgruntled former associate, as a documented sworn witness account provided to federal investigators during an active criminal investigation into one of the most serious sex trafficking operations in modern American history. Melania stood behind the White House podium and told the world Epstein did not introduce her to Donald Trump. The FBI document states that he personally did. These two statements cannot peacefully coexist in the same reality. One is the sworn testimony of a cooperating witness who faced federal prison if she lied to investigators. The other is a scripted statement delivered by a woman who has spent considerable resources pursuing aggressive legal action against anyone who dares to challenge her authorized biography. The contradiction is not subtle. It is not subject to interpretation. It is a direct factual conflict between what a federal document records and what the First Lady publicly declared. Then there is the Paolo Zampolli complication, which drags this entire narrative into even more significant and uncomfortable territory. Zampolli is the man who has publicly claimed credit for introducing Melania to Donald Trump. He is the individual whose account forms the entire alternative origin story, the chance encounter at a party, the "it was Zampolli, not Epstein" narrative that Melania's entire defense depends upon. This same man now serves as the president's special envoy for global partnerships, an official position in the administration. And the FBI document reveals details about Zampolli that raise profoundly serious questions. The document discloses that Zampolli had a romantic relationship with the cooperating witness. It reveals that Zampolli attempted to purchase a modeling agency jointly with Jeffrey Epstein, the very same agency that reportedly represented Trump's own daughter when she was a teenager. It details that Epstein was visiting Zampolli at that agency during casting calls for young models. The man whose account anchors Melania's entire defensive narrative, the man whose story she relies upon to dispute the Epstein introduction claim, was apparently engaged in business negotiations with Epstein, while the agency conducted business with young, aspiring models. This is the foundation upon which Melania's entire defense rests, and the FBI document has cast serious doubt on that foundation's stability. Wolff has not made public declarations of victory. He does not need to issue triumphant statements. The sequence of events communicates with considerable clarity all on its own. Melania held a press conference denying everything and characterizing her critics as liars engaged in defamation. Wolff stated that her remarks contradicted the evidence in his possession. The FBI document emerged from the released files and directly contradicted her sworn public statements. The document simultaneously raised troubling questions about the credibility of the man whose account supports her alternative version of history, and the lawsuit that Melania's legal team has spent months trying to dismiss, transfer, delay, and neutralize through every procedural challenge available is still sitting in federal court, alive, active, and advancing through the judicial process. Every motion, every venue dispute, every claim of insufficient service has bought her additional time, but none of these procedural maneuvers have made the underlying evidence disappear. The photographs still circulate in the public domain. The social connections remain extensively documented. The threatening legal letters are preserved in the public record for anyone to examine. And now the FBI document exists, a government-generated piece of evidence that presents a direct and substantial challenge to her public statements. Wolff's third theory about the press conference is perhaps the most psychologically penetrating of all. He suggested with considerable candor that Melania harbors deep frustrations with her husband, that Donald Trump is fundamentally connected to her current legal difficulties, that his world, his friendships, his extensively documented social connections with Epstein are what brought her into proximity with the most legally toxic name in recent American jurisprudence. And now, as Wolff frames the situation, Trump is engaged in activities that create serious complications for Melania's carefully constructed public identity. Wolff's interpretation of the press conference is that it was not purely a defense of Melania at all. It contained elements of a signal, an implicit communication that the man whose associations created this entire predicament deserves his own share of scrutiny. Under this reading, she used the White House podium to quietly, in the coded language of her prepared remarks, suggest that her own husband's connections warrant examination. If Wolff is correct about even a fraction of that interpretation, what occurred at that White House podium was something genuinely remarkable in the context of the American presidency. A sitting First Lady using the most prominent platform available to her to subtly indicate that the man occupying the Oval Office deserves precisely the same scrutiny she is currently receiving. receiving. That transcends ordinary political commentary and enters territory that suggests profound internal tensions within the administration itself. The legal proceedings continue to unfold. We do not yet know how the judge will rule on the competing motions currently awaiting decision. We do not know whether the case will remain in federal court or be remanded back to New York State jurisdiction. We do not know if the Florida transfer strategy will ultimately succeed or fail. We do not know the complete inventory of evidence Wolff claims to possess in his case file. We do not know what other information may still be contained in those millions of pages of Epstein files that remain unexamined or unreleased. What we know with certainty is this: a journalist refused to accept the billion-dollar threat and retreat into silence. He filed suit against the First Lady of the United States. She responded by holding a nationally televised press conference about an active federal case, a move that legal observers recognized as highly unusual. Her opponent immediately declared that her public statements contradicted the evidence he holds. Within a compressed time frame, an FBI document surfaced that validated the core questions Wolff has been raising throughout this entire saga. And the case is still progressing through the judicial machinery, still carrying with it the potential to require sworn testimony from people who have expended considerable effort ensuring certain questions were never asked in formal legal settings. Melania Trump has constructed her entire public existence on the premise that the story she authorizes about herself is the only story that matters, and that anyone who dares to tell a different version will pay a substantial financial and personal price for their temerity. Michael Wolff examined that price tag, calculated the risks, and refused to retreat. The emergence of the FBI document now suggests with increasing force that his refusal was justified. The questions that Melania has devoted significant resources attempting to suppress are doing what uncomfortable questions invariably do when the evidence begins to align against silence. They are continuing to surface, continuing to demand answers, and continuing to exert pressure on the carefully maintained facade. Whatever happens next in this extraordinary legal confrontation, however, the judge's rulings reshape the procedural landscape. Wherever this case ultimately travels through the American judicial system, one thing has become increasingly clear: the truth has a way of emerging, and no amount of legal intimidation can permanently contain it. Stay connected to this story, because when that judicial decision arrives, when the next revelation surfaces from those files, every dimension of what this means will be broken down right here.